Breaking news! Join me as I dive into the legal chaos and challenge myself to uncover the truth behind Fani Willis being ordered to pay $54,000 for breaking the open records law. Fani Willis is a well known prosecutor in Georgia, and in her role, she is supposed to uphold the law, not break it. But that's exactly what happened when she violated the state's open records law. And today, we're going to dive into the details of this incident.
Well, we are following some breaking news tonight at 6 as a judge has now ordered Fulton County District Attorney Fani Willis to pay more than $54,000 for violating the Open Records Act. Zach Merchant with our 11 Alive political team broke the story. And Zach, you just got a copy of that court order. What have you learned here?
We did. We just got a hold of this Fulton County Superior Court order just in the last roughly 15 to 20 minutes. In it, Judge Rachel Krause rules that DA Fani Willis violated the State Open Records Act by failing to turn over documents requested by defense attorney Ashley Merchant. The judge wrote that the defendants, the Fulton County DA's office, were openly hostile to Merchant and failed to handle her requests in good faith. Merchant had sought a copy of confidentiality agreements signed by DA's office employees, as well as a list of attorneys hired by DA Willis. Judge Krause today gave the district attorney 30 days to pay Merchant $54,000 in attorney's fees and to turn over those requested files. Spokespeople for the DA's office did not immediately return requests for comment.
So let's back up a little bit. Let's talk about public records law and their impact on transparency with government. See, public records law, also known as the Freedom of Information Acts, FOIA, or Sunshine Laws, ensure government transparency and accountability by requiring certain government records to be open to the public, allowing citizens to access information about the government operations. The purpose of these laws aim to promote transparency and accountability in government by giving citizens the right to access information about government activities and decision making. In court cases, these laws play a crucial role in ensuring public access to information while also acknowledging certain exemptions for privacy and security. But in court cases, for transparency purposes, public records ensure that court proceedings and documents are generally open to the public scrutiny, allowing citizens to observe and legal process and understand government actions. For examples, here are some examples of public records dealing with court cases. Court documents, including case files, documents and orders, police reports and criminal records, minute meetings and agendas on public bodies, budget information, and financial orders. So when we look at the Trump case, YSL case, or any court case, these examples are documents that the defense team will actually request from the prosecutor's office, and they have a right to these documents under the open record law. So how does this pertain to Fani Willis and her role as a prosecutor? Well, back in 2024, Ashley Merchant, if you guys remember, accused Fulton County DA office of violating the state's Open Records Act. This lawsuit accused Fani of hiding documents related to the media monitoring company, alleging the district attorney had used taxpayer dollars to pay for it. It also accused the Fulton County District Attorney's Office of not wholly fulfilling open records related to employees' non-disclosure agreements. This refusal sparked a lawsuit, and ultimately, the court ruled in favor of Ashley Merchant Law Firm, stating that Willis' office had violated the open records law by denying access to those documents. Now, the implications of this incident are huge. As a prosecutor, Fani Willis is supposed to be transparent and accountable to the public, but by refusing to hand over those documents, she undermined accountability and created a lack of trust between her office and the community that she serves. It's even more concerning when you consider that the documents in question were related to a high-profile case and the public had a right to know what was going on. And we all know what that case was. It was the Trump Georgia RICO case. So the open records law in Georgia is in a place to ensure the government remains transparent and accountable to its citizens. It's what allows us to request documents and information from public officials, and it is what keeps those officials in check. By violating this law, Fani Willis sent a message that she's above the law, and that's a dangerous precedent to set. Now, we have been covering Fani Willis for the past year, me and Judge Joe Brown. And every time we talk about her and her actions and the actions of her office, we always include how they act in intent of being above the law. That is a problem. She really believes she's above the law, and we see that by her actions. We see her by her having a personal relationship with Nathan Wade, putting him on payroll. We've seen that when she entered the court and had a major attitude problem, just a bad disposition. Fani Willis, ever since she's been elected DA, she has acted as if she's above the law. Now, this is the second time that she had lost an open records case, because back in January, she was ordered to pay $22,000 to the Judiciary Watch. So let's proceed here. The court's ruling was clear. Fani Willis' office had violated the open records law, and as a result, she is now ordered to pay $54,000 in penalties. This is a significant amount of money, and it sends a strong message that the court takes violations of open records law very seriously. So what were the reasons behind the court's decision to impose such a significant penalty on Fani Willis? Well, according to the court documents, the judge was particularly concerned with the fact that Willis' office had refused to hand over documents despite multiple requests from Ashley Merchant's law firm. The judge saw that this is a deliberate attempt to circumvent the open records law, and that's why the penalty was served. The court's ruling in this case sets an important precedent for future cases involving open records law. It sends a message to public officials that they will be held accountable if they violate this law, and it gives the public more confidence in the system. Remember, listen, when we talk about the DA office, the prosecutor, who are they supposed to be representing? They're really supposed to be representing us, the people in that community, in that county. So we need to have trust in them, which is why you have these set laws as open records law. But we also hire defense attorneys to represent us when the prosecutors who are supposed to be serving the very people are prosecuting those same people. So that defense has a right to all communication records for the purpose of that court case. So with this particular lawsuit, yes, it is going to set a standard, and it's going to put on notice DAs, not just in the state of Georgia, other states throughout this country, that you are not above the law. And how many other law firms are going to use this case judgment to make their point in court? So this is a win-win for Ashley Merchant and we the people, and a lose-lose for DAs and the prosecutor's office, and especially Fani Willis. Now, I do have a question. Is the $54,000 coming out of the DA office, or is it coming out of Fani Willis' bank account, personal bank account? And I want you guys to answer that question for me in the comment section, because I don't know. And I think that's a fair question. Are we the people, well, the people of Georgia, have to pay for Fani Willis fuck ups? Or is this a personal penalty that she has to pay out of her own personal purse? Please answer that question for me in the comment section. So let me say this. One of the reasons why the judge, I believe, sided with Ashley Merchant in this case was because of this disgruntled, hostile witness that took the stand. Ashley Merchant called this person is an employee under Fani Willis in the DA's office, and he was called and he was actually subpoenaed to show up to this hearing. But he was very hostile, very sassy, very nasty.
I know that we do not have any requests related to employees in any signed forms saying that you cannot speak to the media. I know that to be certain. So I did not do anything as it relates to this open records request based on my interpretation, and my interpretation is because required signing regarding speaking to the media. So let me be very clear. For that open records request, I did not do anything because I read it as required signing regarding speaking to the media.
But you personally thought this was elevated to you for some reason.
This was elevated to me, and when it was elevated to me, it was presented to Mrs. Merchant want media statements. Do they exist? No, they do not exist. To which I responded to your open records request, they do not exist.
Were all of my records requests after January 18th, were all of those elevated to you?
No, I don't. You have, again, we disagree on a number. We know there's a lot. If you have asked for my office back from September, a lot of standard things, all of which we responded to in a timely manner. I hope you can agree to that. So I don't see all of your requests.
Did you sign a confidentiality agreement?
No.
You've never signed? So. You've never signed one?
I don't think so.
You don't remember?
I don't remember. I don't think so. I do not think so.
Do you believe that only 22 employees of the district attorney's office have been required to sign a confidentiality agreement?
I don't have no belief. I don't have a position on that. I know my staff. I could speak for my staff. No. And what I think I gave you were.
I'm sorry? You think you gave me?
No, I can speak for me. I don't believe I signed one. I know that my staff, my direct reports, they have not signed one.
Your direct reports have not?
As it relates to my direct team, I did not administer, I did not facilitate the signing of those particular documents. So I cannot speak to that.
So at this point, the 22 that we've received, I heard testimony of 150 lawyers, 300 or something.
I have a list of, hey, here are the list of attorneys hired by District Attorney Willis with their hiring date. And I can tell you right now, as I sit here, I don't have. Ma'am, look at number 9. That is 2 requests in 9. So you cannot correlate Roman numerals to request.
2 requests in number 9?
Look at 3, 4. I'm sorry, don't Roman numerals.
Objection, I'm sorry. I understand that counsel is trying to get to the contents of the letter. At this point, I don't see the relevance in having the witness count the number of requests in the letter. So if we could just get to it.
Just part of the argument has been that it's burdensome, that I requested 40 we started with. There's 10. One of them I had to duplicate because it was closed without being responsive. There's 10.
The letter, I can read your letter.
Okay.
I know how to count and read. No point in arguing about it.
You responded to that letter and said nothing exists,
In
correct?
this letter, you presented 10 Roman numerals that dealt with a lot of different requests that was outstanding, but you so commonly forget that we have had several different open records requests outside of this particular letter, dating from September. So this letter only deals with open records that was outstanding. Each Roman numeral deals with various different requests. Let's be clear.
My question was, if you sent a letter in response to this.
You asked me that 3 times. The answer is yes. You received it on January 26th.
And it said, that you do not retain records and cannot produce them.
And I told you that 3 times because as I sit here, I do not have records. I do not have a list of hires from attorneys with the date of hire that was hired by District Attorney Willis. I told you that on the 26th in response to the open records request. I told you that now, and I told you that previously.
One point of clarification, because you've said the same thing several times, and you're putting emphasis on a particular part that I'm curious about. Call it the rule of judge's interest. But I understand, and I think I started this hearing with this discussion about sometimes we know things that don't exist in a document. But you keep saying I don't have a list of attorneys with their hire date who were hired by Attorney Fani Willis, the DA Fani Willis. Weren't all the attorneys in the DA's office hired by Fani Willis?
Oh, no. Where's the DA that was hired by District Attorney Paul Howard?
Well, I'm certain they have worked for the DA's office for a long, long time. But didn't she decide to hire them when she became the DA? And I'm not challenging you. I'm just asking to make sure I understand if there is or is not a distinction.
I see that. Yeah, I can see that.
Okay, fair enough. I mean, but at least I understand better why you were drawing that distinction.
Mm-hmm.
Okay.
Well, I was drawing that distinction because that's what she asked for.
Okay.
And
No,
I got you.
I wasn't challenging what it said. You were placing emphasis on it in a way that to me seemed to inform how you understood the request. And now I have a better understanding of how you understood the request.
Thank you.
Okay.
Thank you, Your Honor. I will say this, based on this particular request, what I have done is to reach out to the Chief Human Resources of the county to see if I have a list of, hey, here are the list of attorneys hired by District Attorney Willis with their hiring date. And I can tell you right now, as I sit here, I don't have that.
When did you reach out and make that request?
Doing it to the county HR in the course of this litigation.
Okay, so not when I filed the open records request.
I didn't have to at that time because I know I didn't exist. So the answer to your question is no, I didn't feel the need to reach out at that time.
But then in response to the litigation, you did feel the need to reach out and actually ask the question?
Well, once litigation is, I'm like, okay, what can we do to resolve this matter? Is there anything extra? Let me do. I feel comfortable. Let's be very clear. Under the Open Records Act, I did what exactly is required to be the law. Now we're in litigation. Let's see if there's anything possible else that I can do. I did that extra, and guess what? The records still don't exist.
And I know we already verified that as the open records officer, you were charged with maintaining records under the State Records Management Act, correct? We already talked about that, right? Early on, that's part of your job.
The Office of the Fulton County District Attorney seeks to maintain records and consistent with the State Retention Act. Yes.
And that act requires that your office maintain records documenting an employee's work history in a case file, including the date they were hired, and if there was no hire decision. And you have to keep those records for 50 years or 7 years following the date of separation of the employee. And you're mandated to actually keep them in your own office. You can't delegate that responsibility to a central agency.
So you're reading the retention law, and I have not read, but I can tell you this. You started the sentence saying as it relates to personnel files. So you said case file data, right? In your open records request, you're looking for a list. I'm afraid you're misleading the court because you're convoluting a retention record that discusses personnel files, but you're seeking via the Open Records Act a list. Those are two different things. So let's not put the list into State Retention Act. They're two different things.
Did you have personnel files?
Go ahead.
Did you have personnel files?
Did I or do I? Yes.
Both. Did you?
Yes.
And you did?
Yes.
And do those include the date that someone was hired?
Yes. The personnel file should have the date that they was hired. The answer is yes. Do I have a list? No. I don't have a list. And if you think that it is reasonable for me to go look at find out who was hired by the DA, pull that HR file, scan that HR file to make a list, I don't think that the Open Records Act requires me to do so.
Well, not so fast, because the Open Record Acts do require you to do so. That's why you lost. That's why Fani Willis have to pay $54,000 in damages, because she did not follow the law. So, and this is part of the reason, if not the main reason, why the case against her office, because this is a case against the DA's office, which is why he's on the stand, because he's a part of her office. This is why they lost, because they're trying to pull a rabbit out of their ass, trying to confuse or, tilt off Ashley Merchant's game here by giving her attitude, giving her too much pushback, acting like they don't know. Do I have a record of this? Yes. But do I have a list? No. Okay. If you have all the records, you have an assistant, tell them to create a list of the damn records. A list is just 1 through 10 of names. But if it's 10 people that she hired, you have all their records. So it's just like he's doing a lot of cosplay with words. And that judge, even though she seemed like she was being polite and nice to him, she could see right through the BS. They broke the law. So the reaction from the public and legal experts has been varied. But one thing is clear. Fani Willis' violation of open records law has damaged her reputation and undermined the public's trust in her office. Many are calling for a greater accountability and transparency from public officials. And this case has sparked a wider conversation about the importance of open records law. Why is it important? It's important because outside of the Trump RICO case, you have hundreds of people who have been sitting in a Fulton County jail that have not seen a judge because they have a major backlog. Now, a lot of these people, they can't afford top-notch law firms like Ashley Merchants and others. A lot of them are poor or just middle class. They probably have to rely on a public defender, or they probably have no defense at all. So they're probably not even aware of the Open Records Act, which is very important and vital to the defense, to a person that's trying to fight their case, especially when one is innocent. But whether they're innocent or not, you are innocent until you are proven guilty, and you have due process. You have the right to due process. So with Fani Willis' office losing this case, and this is nationwide news, this is some vital information that anybody who is going up against a prosecution office and you feel as though, you may not have the means for a top-notch law firm, or that you have a public defender, or maybe you just have to defend yourself, you have to know your rights and what you are, by law, legally capable of obtaining, such as open records. And those open records are meetings, are financial statements, are court documents of information that the prosecutor's office have that you are privy to reviewing and having copies of. So for him to sit here and play dumb or downplay his role is very disheartening. And that is why we, the people, do not put our trust in the justice system, especially when we're talking about a prosecutor's office. So in conclusion, Fani Willis' violation of the open records law is a serious situation that has significant implications for accountability and transparency in government. The court's ruling sends a strong message that public officials will be held accountable if they violate this law. And it reinforces the importance of the open records laws, not just in Georgia, but in all of the states throughout this country. But this is not the last, honey. No, this is just the beginning. This is the downfall of Fani Willis. Yes. So in total, so far, she has to pay, let's say, 54 plus 22. That's 4, 5, 6, 54, 22, $76,000 for lying obstruction of justice, for acting like she's above the law. She still has to answer to the Georgia Senate, and she still has to answer to Congress. But thank you guys so much for watching. And don't forget to leave your thoughts and comments below in the comments section. Please like and share this video. And I will see you guys in the next video. Bye.
Dana with the data. Dana with the data.